but I can't. Can we get Mr. Lee out? No, oh, is he? Okay. Right. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Marie Tin, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry?
Mr. Rubio. Oh, there you are.
Good afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Kwasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Rubble sent me, as well as Mr. Burgess and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Rubble, who's the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Rubble has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
because it would have been unethical for Mr. Burgess to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
well,
Mr. Burgess may not have done.
And that may very well be. But Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that. Judge, trust me. I know that. But I just wanted to make a record. What, can I just finish though?
Let her finish.
Mr. Lee indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements, the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if maybe if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with interrupting.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabo is making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quadley, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quadley not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. If it has gone to law enforcement now, and we can follow up.
Mr. Arabo.
Your Honor, as you know, I'm a defense attorney. I think it's Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what he's being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how this slipped between the clients, because in over 10 years of practicing, I've never seen something like this, where a victim turns into a defendant during a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever's representing Mr. Quasny, so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quasny using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this. And it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody listened to it already.
Can somebody send it to Ms. Weidling, and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and court listen to the call.
You have to go back.
I'll handle that coming back out. But I think Miss I can go on that. So bring me that.